we're going back to radio. It's fantastic. And by phone allows a trial lawyer like me to walk around a lot. And don't get to see me. I want you to just conjure up an image. Imagine sort of President and George Clooney sort of morph that has absolutely nothing to do with what I look like, but is the image I'd like you to hold on to for the next hour and a half. Jane, as a nice introduction, but about 20 articles, not 200 articles. I don't have that much today.
Oh, sorry about that.
Oh, that's great. But I want to start a little bit, a couple of things about that bio, not out of any sort of aggrandizing or background, but just to try to put some perspective on a couple of things that I want to talk about today. I'm thrilled you're all here. Extent that Jimmy and the technology allow to have questions, discussions, I'd love to do that. But Jane, I've been doing this stuff, prosecuting cases for about 35 years. And as I say, about 190, almost 200 felony cases. By perspective, for what I'm going to talk about, I probably handled about 200 homicide cases over that period of time. Probably tried about 60 of them. No body homicides to a 23-year-old I'm told was the oldest in the country at the time, to doing a death penalty case, which was the last one the state ever does. I have the first prosecutor on the West Coast to DNA evidence back in the mid-1980s. And because it's my favorite sentence of my career, and it'll give you something to think about, I had a sexual assault case where the victim also testified as a defense expert. It's a long story, but it's a great line. I say all that to put some context to what I want to talk about, which is this. With that sort of long background of stuff, I think that the decisions that prosecutors make regarding adolescents who are accused of sexually aggressive behavior are the difficult decisions that we make. It's the hardest thing we do day in and day out. And as a general rule, I think it's a thing that prosecutors just do the worst. We are bad at this, and as a group, not individually, but it's a sense that trying to distinguish between dangerous juveniles who have been used to sex crimes and just adolescents who have committed acts out of immaturity or impulsiveness is perhaps the most difficult task that we take on. And the way things are structured, it's done in a way that we're just not particularly at it. I'll find for you 6 reasons I think contract, and within all of that, offer some thoughts as best as I can on sort of what are problems and what are solutions to them, and to the extent that the technology and Jimmy's incredible skill can allow this to become a discussion, I want to encourage that. But there are 6 things, and these will all go. There'll be some slides. They'll be made available to you right after this is over. But Jane, is the next slide starts with the 3 bullet points. And I'll put all 6 of these up so you have some notes if you want and a structure for the talk. The reason we're so bad at this and the reason this is so difficult, again, these 6 reasons. The is we really bad public policy regarding juvenile sex offenders in this country. I'll explore that with you. I think some of that decision-making and much of that policy is based on misguided fears of this relation. It is committed by greatly misunderstood notions of risk and recidivism. The next slide, Jane, it talks about the failure to recognize both through the system, the failure to recognize some of the unintended consequences of typical but often ineffectual interventions. So these policies in place, and we the consequences of actions are often worse than the problem we're trying to solve. All this, I think, is somewhat exacerbated by mystic and often irresponsible clinicians and experts who have financial interests in maintaining a status quo, even of things that don't work. I refer to that in this slide, opposite guide, guild interests, ideologies, irresponsible experts, and we'll talk about that. Finally, sort of a call to my own colleagues. I think a lot of this ends up being compounded. Prosecutor's office is known, which I like. Often don't appreciate all these factors, and they don't have their offices structured the proper and thoughtful handling of these cases. So I've asked that as a question in the slide. So those sort of 6 factors to me go into what is a problem with handling these cases in the most effective and efficient way. So let me start with public policy. And I think important, I know that some of them on the call are policy makers and influencers. And those, especially who aren't, I sort of talk a minute about how public policy, especially in the interpersonal violence, is made. And recognize the field of sex offenders and know about it. This field is 30 years old. We've been researching this by and large for a short period of time. Organizations in this field were formed in '87 and '89. We're a young field. Problems have existed for a long time. Tried to create some since before we had data. And it's not exactly on point. I think the best illustration I can think of to talk about policy, somewhat related, research I want to talk about. Without feedback, you won't be able to answer this question, so think about it and ask your especially your non-professional friends about it. What day of the year do you think is the most dangerous day of the year for a kid, a child, to be sexually molested? If you had to pick one day of the year, one event that you were most fearful of, just intuitively, what would you think? What would you pick?
And Jan, unmute if folks want to.
Just unmute a minute and see what people offer for that.
Unmuting like a crazy person.
I'll do like a sane person. It'll work better.
What do you think? Well, if you had to say one day of the year. Anybody have any thoughts?
If typing that into the chat box, we can hear you.
Hey, Thanksgiving.
Thanksgiving, all right.
Sure.
This is Jackie. I agree. That's what I thought of.
What about Thanksgiving, do you think, that leads to more risk?
Everybody's at home and in a bad mood. It actually is, it's well thought to be one of the highest days of the year for domestic violence.
Yeah.
And I heard from Renee Mercury in Kansas, Halloween. Samaya from South Carolina is saying Charleston's voting for Christmas.
Okay. Well, all perfect sense, folks, and especially those not in the field, think it's Halloween. I mean, what would people the most? We're sending kids in costume, in the dark, door to door, allowing people to dress up costume. Oh my gosh, all this stranger danger stuff with these running around. And sure enough, lots of policymakers about 12 years ago around the country started thinking Halloween was the most frightening day. So states in Virginia and places in Massachusetts and New York and New Jersey, I know New Jersey's on the phone, jurisdictions passed that all sex offenders had to a curfew. I think it was Virginia, where they all had to go to a probation department, and all the probation officers were called in overtime to sort of babysit the registered sex offenders. Police were called in extra time to eye on the sex offenders who had to go into a police station and be monitored. Makes great sort of sense if you think that's a really the most dangerous day. And when reading about that, it dawned on me that over 20 years of prosecuting these cases and looking at about 400 every year, I remember a single case that happened on Halloween. So I had we had a fairly sophisticated computer system in our office, and had the people in it. Had we had any child molestation cases come into our office with a date of crime of October 29, October 30, or October 31. About 13 years of data. 13 years, about 400 cases. We had a case referred to our office for a period of time. That's less than chance. And I mentioned that to other researchers in the field, including Jane's colleague, a fellow named Mark Chaffin, a colleague of Jimmy's, and being the greatest researcher in this field, able to get into some database and look that up and get about a dozen years of research covering some 65,000 cases. He took that data, worked with two other researchers, one out of Florida named Joe Lesson, one in South Carolina named Elizabeth Letourneau, and we produced an article that's on the slide called "For Trick-or-Treaters," 9 years ago. And what I found was, looking at 65,000 cases over more than a decade, any other autumn day. Now, that's the argument to have subtitle, because I also had him run how likely you were as a kid to be molested on Arbor Day, and apparently Arbor Day was actually more frequent than Halloween, but we thought that was sort of besides the point. There's absolutely no correlation. So all these counties and all these jurisdictions were spending oodles of money on overtime to solve a problem that statistically didn't exist. For one thing, your kids really are at far greater risk on Halloween than any other day of the year for one thing. You have to figure out what that is. Getting hit a car. Your kid is 4 times more likely to get hit car on Halloween than any day of the year. These cops who are inside watching all these sex offenders who put no greater risk would have done much greater service if been called in to, in the street and monitor traffic, they would have been much more helpful. Why do I start there? Because microcosm, I think, of how public policy dealing with juveniles and interpersonal violence starts. We think of a problem. Well-intended people go, hey, I know a solution. I think we can figure this out. Come up with an idea. There's data to support the problem. People get invested in the idea. Somewhere along the line, somebody actually comes up with some data, and we do research and realize, oh, you know what, that didn't really work, and we didn't fix the problem, and maybe there wasn't really a problem. And the unintended consequences of this, all the cops are watching the sex offenders on that particular day and not patrolling traffic where they actually do some good. We've actually created more of a problem than what we were trying to solve. This is fantastically true with adolescents who have been accused of sexually behavior or juvenile sex offenders, whichever term you want to use. It's ironic that my state, Washington State, basically provided a lot of this bad public policy to you. In 1991, the state passed a very intensive piece of legislation called the Community Protection Act. And it had three components to it, which have been adopted in some form, many of them across the country. And they reflect on how we got here. Well, the three pieces of legislation, components of it, was notification of sex offenders. If the sex offender is going to be released, we're going to tell the community about them, depending on risk factors. Registration of sex offenders, that somebody in a community, they're going to go to the local police or wherever in the jurisdiction and register where they're living. We added the sexually violent predator law, which allows for the civil commitment of some types of particular sex offenders when they're going to be released. 19 other states adopted such a statute, so the 20 states now have that. How am about? Well, we had that case. It's always the poster child case. Fellow out of prison. I may have the order of these two things, these two offenses wrong. This is right. A fellow named Wesley Allen Dodd came out of prison. He was a convicted sex offender. He moved to Vancouver, Washington, a suburb of Portland, Oregon. And in fairly short order, found a young boy, sexually molested him. The child was found in a closet, a whole crime. And local media, horrified that had just been released, went back to the prison and know about this guy. And all the treatment providers there went, oh, we knew he was going to do this. Scared the hell out of us. We knew he was going to do this again. Well, why did you come out? Well, we had no choice. He had done every day of a sentence. We had no options. Or scratch your head, a fellow named Briner, got to prison. A young boy at a park in Pierce County, about halfway between Seattle and Portland, and assaulted and sexually mutilated this little boy. Same thing. Media went nuts. He came out of prison, went back to prison people. They said, yeah, he said he was going to do something like this. Well, why didn't you do anything? Well, nothing legal for us to do. Really, really smart people, really thoughtful people, really caring people decided to do something about it. A fantastic committee of well-intended folks got together and created this Community Protection Act and said, great, we're going to require these people to be registered and in another community, and if they're really that dangerous, we retain them like we do who who is mentally, has a disability or mental abnormality, who poses risk to themselves. You walk around the street with us and say you're King Charlemagne and you're going to go kill people. We tend to civilly commit a person. So this formed a civil commitment. If they had a mental abnormality or personality disorder, they may be likely to engage in predatory behavior. They could be civilly committed. Used to cases, fun cases. All sounded great. Fact, in various other states, people adopt these things, often in relation to a particular case. In various states adopted various versions of these, all naming them after a particular child. So we end up with, law and Jessica's Law and Animal Act and whatnot. Intended facts caught up to this thing, what really sort of ever happened, the effect of these things, and what were the unintended consequences of these things. What I suggest, and we'll go through, what I've suggested is that the reaction to the heinous has really done a disservice to prevention and service to the public. We have scared out of people, and it's caused us to sort of take off of what we really ought to be focused on. So that public policy is based sort of on this fear as opposed to facts and data to try to piece together what we ought to be doing. Slide, Jane, which is about why does this happen, I think is sort of a summary of a lot of how public policy gets made. We want to solve problems, but there's a proven effective solution. Time to wait for science to catch up. So and do the best we can, and smart, well-intended people are sort of, guessing and intended, but we don't have the data. Once we create a system, people get tested, money gets invested, assumptions become facts, facts become conventional wisdom becomes dogma, and as I'm going to discuss a little bit later, those who sort of benefit from that system and that status quo tend to start rejecting facts to the contrary. The papers, Jane, at the beginning, she was going to one other article at the end of this, and that's a paper the fellow Chaffin wrote, and we had talked about, knew for all this, facts were, and what research showed, but once the policy gets made based on fear, it's real hard to sort of turn that ship around and alter it, big data. Part of my starting here is sort of a call to my colleagues, my prosecutors, to take a look at why is this policy, why is this law, why is this statute in the first place? What are we trying to solve? Really try to ask, it actually solves the problem or addresses the situation we're trying to address, using all of the other colleagues in the community to sort of find the facts and get the research and try to figure this out, try to alter those laws, or as I call for in this paper, to create systems in the prosecution process that best protect the community and reduces recidivism. I mean, my view as a prosecutor, we're the interventionist. We come in at the end of the case, but boy, it sure would be great if we could, to the extent possible, become preventionists, because I love to get involved in a case do something so I never see those people again. So part of the take-home message I want to sort of size this thing is, does the public policy make any sense, and how does it comport with the facts that you've got? So, to the extent you want to unmute, if anybody has comments, thoughts about that, and then I'll move on to the next thing, if that makes some sense.
Yeah, absolutely. I just sent a chat out in the box to let people know that if they have thoughts or wonderings, to please use the chat. I'm unmuting people right now. This is your opportunity to talk to an expert, someone who knows a lot about the field. Our chance is dwindling to put your voice out there and talk directly to Paul Stern.
No. So I think part of this policy is based on some misguided fears of juvenile sex offenders. We used back in those days terms like the super predator. And I'm not discounting the fact that there are some juveniles who commit sex crimes who are breathtakingly dangerous. And we really need to be incredibly careful and those. But they're trying to identify who those are and thinking this is the entire class as, I think, creates some really bad public policy. What happened? Why is lines like the super predator and the fear inform public policy? Well, if you watch, fear sells. Entire industries, the insurance industry, the home security industry, the entire pharmaceutical industry is sort of premised on fear. You can't watch a nightly newscast without getting, minutes of, my God, you have this disease, and if you don't take this pill, horrible things are going to happen to you. We are completely inundated with the selling of fear, and I think in public policy, fear of the juvenile sex offender, or of the sex offender in general, without recognizing the distinctions between juveniles, has promoted that kind of policy. Naomi Klein's written a book called The Shock Doctrine, which sort of talks about the impacts to the system and its ability to create what we refers to as sort of draconian impacts. And I'm not taking this at that far, but I think we have a little fear of adolescents who have engaged in sexually aggressive behavior. It's based, to my mind, a lot on misunderstood notions of risk. And if you move along the slides, Jane, there's been plenty of research over the last 6, 7, 8 years now. A comprehensive study published 2 years ago, a year and a half ago, by Michael Caldwell, that looked at a meta-analysis that the rent rate, the recidivism rate for juveniles who have been convicted of sex offenses was 3%. That most juveniles who commit sex offenses are who have been have committed non-sex crimes, that are on other things than moves to a sex crime, and they pose a greater danger than those who have been convicted of a sex crime as the initial index offense. a study came out, 2 days ago in Pennsylvania about the and what went on there. I was reminded that when the Boston Globe covered that the Boston Catholic Church scandal and the movie Spotlight, which they relied on, suggested 6% of the priests in the country had sex offenses. Just sort of that's right. It's sort of a thing that priests pose twice the risk of making an offense than a once kicked a juvenile sex offender. And you have this notion of fear of some of these kids. For 10 years now, we've known that low few crime rates among juvenile sex offenders had been replicated with a rope finding with long-standing scientific publication. And that's just an overriding concern. So we've got this fear risk that appears to be fairly unfounded. To emphasize something I said a moment ago, the few sex crimes are more likely to be committed by a previously non-sex offending juvenile than a adjudicated juvenile. Well, why is that? Research that I've tried to rely on in the paper that was disseminated in the paper that will be sent out to you by Jane pretty makes clear that the age for juveniles who offend against other children is 12 to 13 years of age. That's the peak age of when these offenses take place. There are a variety of different types of offenses. They're set forth in this paper. But the peak age is around 12, 13, 14 years of age. Kids at that age? Well, developing a healthy knowledge about brain research and understanding the kids' brains development issues, and most influences kids of that age. Parental supervision, role models. What researchers have found with impacted policy. Most of these juveniles who have engaged in sexually aggressive behavior aren't sex offenders and young adult sex offenders. They're delinquents. Have engaged in inappropriate, illegal, delinquent behavior, sexual as opposed to a sex crime because they're a sex offender. They're as likely to have broken into the movie theater or tried to steal from the vending machine or the house than are being the serial child molester. And you better than I do that the field of therapists know deal with delinquents. Those therapies. And trying to deal with delinquency is a far better remedy than sort of allowing all these kids, young offenders to be, and giving them the specialized sex offender treatment and whatnot. They need interventions to deal with that kind of a delinquency as opposed to sex offender specific type of work. But one, of course, is these policies create sort of this one-size-fits-all remedy, which ends up really not fitting anybody. And the problem of the delinquent is sort of used, I think, by our fear of the sex offender. Because, as a prosecutor, there is nothing I feared more somebody was prosecuting going out and committing a worse crime. That was terrifying to me. For a dozen years, I ran our domestic violence prosecution unit, about 450 felony referrals coming into our office. And one of the first things that I did is rename the unit from the domestic violence unit to homicide prevention unit. That would change people's thinking about what we were doing. We, of all the homicides in my jurisdiction, pretty much most places, are violence. So I wanted to put the emphasis on risk reduction. We were the homicide prevention unit. And knock on wood and a whole lot of luck, we got lucky. Well, 10 years we were there, not a single domestic violence homicide was committed. We had plenty, but not a one had been from somebody we had previously prosecuted. We were trying to properly identify and distinguish who posed the greatest risks based on some of the best research we could get from, and that's, Ontario risk assessment and research. So I sort of think in the juvenile field, where if we're trying to figure out the risk and who we most want to concentrate on, what we're trying to accomplish, what I do is most of my energy as a prosecutor, one size fits all. We're just going to whack everybody who comes around because that's what we. But poses the greatest risk. Who's the most likely? If the recidivism rate is in fact 3%, there are some suggest it's less than that. There are some obviously who think it's higher than that. Yeah, it's still. But if we're trying to figure out who among those 3%, if that's the right number, plus risk, I want to focus my energy on those guys. And how to do that? To me, the best way to do that is to put as much emphasis as I can on assessment, trying to figure out, trying to understand who poses the best risk, that I can best understand the risk of the individual and as some amorphous class. And about that in a bit more. The thing that I had put in my list of things was to recognize the unintended consequences of certain interventions. And here we had that sort of one size fits all. And I noticed there are a couple of folks from South Carolina, D. Norton, that's fantastic, and I think two other commanders there. Some of the latest research on juvenile sex offender registration comes out of the Medical University of South Carolina. Elizabeth Return, her team, a series of a couple of studies, all cited in the paper we sent out to you. But found a couple of really interesting things. There was, I guess, solicitors in South Carolina recognized some of the downsides of juvenile being on the registration and the consequences of that. Among them, just so we're clear, I think one of the things that go into delinquency is this lack of good vision and peer group and role models. So what do we do with kids when convicted and impose all these restrictions on them? Come out of school, so not with other kids who have been thrown out of school. We don't allow them to go to join clubs or sports. We basically put them in a position to narrow the field of good role models for them and sort of do things that some encourage them to be around worse role models. What could possibly go wrong with that? So, and I don't have any cavalier idea that we ought to just be welcoming these folks, but we ought to be careful about what we're doing. So in South Carolina, with the registration, what happened? Those laws went into effect, and this was exacerbated when it went into effect on an online system. solicitors more and more frequently big plea bargain cases, which is perfectly fine, but change the name of the crime from like a sexual molestation identifiable offense to an assault offense. So instead of like the child had engaged in some sexually inappropriate thing, it sounds like they got into a fight. Because an assault does not carry with it the registration type of requirements. Rates and all that statistics are in the paper. I won't belabor them here. But the thing that it did, registration was put in place so the community would learn more about the people who had been convicted of these crimes and know who they were, but because of the unintended consequences of them, and certainly in South Carolina, and certainly, and this is true elsewhere, our desire to get more information about these kids, we get less information about these kids. Compounded. Again, in the 20 states and the feds that have things like sexually violent law, we really are trying to identify the absolute worst of the worst and the scariest of them all. And I have prosecuted people who were juveniles when they committed their underlying offense. Trying to figure out what the underlying offense is, and you realize it's an assault and not a sex crime, you have less information to better identify the most dangerous of the offenders. So the unintended consequences of this draconian information or consequences of this led the community, I think, to get less information as opposed to more information. It created some separation and isolation for these kids. They lose decent colleagues and the ability to sort of impose interns to reduce risk, consequences of probably doing things to increase risk. And it's one size fits all. So the call to my fear is when we're doing things is really, really paying attention to these underlying consequences of what we're doing. The next slide shows a picture of Adam Walsh and refers to some of that Letourneau articles. The long-term public registration of juveniles, she found, decreases those of the prosecution. A desire to gain information, we sort of lose information.
I just also wanted to note that she also found that the youth were less likely to receive evidence-based treatments or treatments because of that were related to the behavior problems they were showing, because it was not part of the court case because they were being charged on a crime that didn't reflect those behaviors.
And Jane didn't rehearse this, but that is exactly the point I was just about to raise.
Okay, because sorry.
The fifth part, you're 100% right. That's what you found. And the fifth point that I sort of talked about where these things go wrong is what I refer to as opportunistic clinicians' guild interest in ideology. And the point Jane made. That in the beginning, I've been involved in the treatment field, was on the board of the Association for the Treatment of Sexual Abusers, was on the board of the both in and out of prison treatment sex offender programs in Washington State. Worked on the DSM committee. I think it was a lawyer in the DSM committee drafting the paraphilias in the DSM-5. What happened, stunningly, and is most juveniles who are educated are treated as if they are adult offenders and just a younger version of them. While, as it was just pointing out, we're really dealing with more of delinquency issues and not ingrained sexual offender issues. So in The research is all cited in the paper. More than 10% of the treatment programs that with juveniles in cognitive behavioral therapy or relapse prevention models designed specifically for adults, the fact that they're in part inappropriate to this population, we need a different type of intervention that, by the way, is more effective, easier to do, and much shorter term. We can do something better, shorter, and more effective, but the most for what we typically do are send guys to the sex offender specialist or the juvenile sex offender specialist. Our statutes require that, which is also a flaw, or lack of understanding of the problem. Or, as I'm about to suggest, once these get in place, those in your community or in this communities who are engaged in the practice of evaluating and treating juvenile sex offenders. Hey, if you're a specialist and need me and I have the special super duper stuff and I run a whole bunch of tests and write a 31-page report, I can charge $3,000 or $4,000 or $7,000 to do an evaluation, which is lunacy, because most evaluations do not require, in fact, probably counterproductive to require a sex offender specialist to evaluate a juvenile, but requires basically a therapist who is skilled in identifying and working with delinquent youth who have knowledge of sex behavior, things like the ATSA, the professional organizations, ethics and code of conduct. That would be a far better model to use, and that is evaluation. It should be a quarter of the prices of what I quoted in these 3, 4, 5 thousand. They're folks who claim they're special and they need this sort of special treatment and special evaluation. I think that is utterly and frankly somewhat of theft. Again, I'll give you the parallel scenario from the domestic violence field, where entity, most of the who are doing all this, they have a policy called the Duluth model of treatment, which research after research article after research article showed absolutely no impact whatsoever. It took, but we shut down all those treatment providers. But to recognize the treatment wasn't effective, it was counterproductive. Boy, the field interest had a little bit of a hissy fit. They sort of didn't go quietly into the night. Eventually, by convincing judges of all that, they did. That sort of takes us to sort of the next step. What happened as you're trying to figure out how to respond to this, recognizing that you are sort of ingrained in the system, the efforts from the system, want to be in that system, and remember the long slide that talked about why do we bad public policy, one of the factors was resist all information to the contrary. So, by way of analogy, when I was trying to shut down the domestic violence treatment program, they come up with their own research. It'd be in these public forums, and I would say, great, tell me the research you rely on. You cannot start a sentence, by the way, with let me tell you about Bill, because it was all anecdotal. There was no research. And prosecutors who are dealing with this and people in the community who are dealing with this, I think, need to sort of recognize that kind of scenario. Great treatment programs that do work. Again, they're listed. Some are listed in this paper of very effective modalities that are available in the community, including the one that Jane and Jimmy are involved with, the Oklahoma PSCBT for adolescents, which is has a demonstrated effectiveness to dealing with the same variety of different models out there. Out of Connecticut, I mentioned, since there's some kid folks involved.
I wonder, sorry to interrupt, but I wonder if you have advised to the prosecutors or others involved in juvenile justice to help them weed through the alphabet soup of services to help them understand, yes, this service is effective for this population, and I can make these decisions in terms of deferred prosecution or other decisions based on the lower level of risk of this youth and the effectiveness of it, because sometimes they sound a lot alike. You mentioned they don't need a $5,000 sexual abuse specialist evaluation, but they will need a clinical intake evaluation by someone who's going to look at problematic sexual behavior. How does a prosecutor weed through that alphabet soup and know what they are getting is what is empirically based?
Perfect question. Which to my last point and come back and specifically address that. One of the problems I think that we have, and I said this from the get-go, the way prosecutors' offices are set up. And again, this is going to be different from jurisdiction to jurisdiction and size, but it's been variance that often prosecutors, the person doing the sex offense crime, there are no juries there. We tend to take a younger prosecutor to give them skills to deal with victims for the first time and to deal with issues, sex abuse issues for the first time. You don't have to worry about jury trials and that sort of stuff, and it's a more informal scenario. So there's a tendency to the juvenile sex offender in a prosecutor's office as sort of a starting point. All these things, and because of the issue that Jane just mentioned, I think it's an enormous mistake. I think it's an enormous mistake for a couple of reasons, one of which is these, I think, are the hardest decisions that could be made. Who's most dangerous? How do you figure it out? How do you work through the alphabet soup of this thing? I think it requires somebody who has experience dealing with these issues, dealing with expert witnesses, and has already built up some community credibility. I think it is problematic because if my theory is true that young prosecutors start there and they think that this is a starting point position and they want to, quote, graduate to, cases. I want to do the homicide cases and evaluate young prosecutors by how aggressive they are. So being aggressive in juvenile court can sort of build a nice scorecard promotion, but it doesn't know the job that you're doing here where just aggressive doesn't actually solve a problem. So I think one of the first places that I would urge is looking at using more experienced folks in the juvenile sex offender position that would be more helpful. Having somebody who has experience, some career security, not worried about confusing aggressiveness with proper decision making, and also somebody who has some skill at sort of identifying and chasing away irresponsible experts, who has some credibility both in the community and with the judges. Of that, I think some experience would come the ability to contacts, have the background to be able to figure out a little bit about what resources are out there, what of the, as Jane says, alphabet soup works. How do you find out what resources are out there? How do you find out what other resources are great? There are some websites that are available that evaluate various types of treatment. Medical University of South Carolina publishes such a list of effective treatments. There's something called Kaufman Center, Kaufman, could be two F's in there. an evaluation of some treatments. And frankly, there aren't very many people in this country any smarter than Jane and Jimmy who know all of this stuff. And we're thrilled to take your phone call or even to say, hey, in my community they're offering X. Is this thing any good? What can you tell me about it? Or is good? The reality that I think the remedy for all this, just like the public is bad when one size fits all, there's no one size fits all remedy for all the communities. I think what we need to figure out is, what do you have in your community? Who's there? Skill sets are there? What talent level do you have? Who are the credible people? What do you do well in the community? And try to build a response system, prevention system, an assessment system based on strengths in your community. Because you can do in a small community, you can do in, low country, where you have great resources and a fairly geographically concise area. It's going to be different than what you can do in, North Mexico, where you have great distances. What funding that you have, what skills you have. So everybody's going to be looking at it much differently. I would have a call for trying to meet with the community to try to figure out it is that you're really good at, and what are the resources, the prosecutors, with the help of the other members, to challenge your treatment providers, the people who are providing certain types of interventions, to say, search that this works. Just because you're doing it, just because that's the way we've always done it, is generally the worst reason to be doing something. So I'm, want to consider the resources and consider the strength and what do you do well. And frankly, I think we can talk about what are great interventions. I think it is probably as important to stop bad interventions than it is to the time and the resources. Stopping bad interventions is as important as figuring out what the best interventions are. Because the bad interventions can often do more harm than almost doing nothing. Back to the DV. Stopping bad treatment turned out to be finding good treatment. Just nothing was better than doing something bad. Feel we do know good things that work. And again, the paper lists some things and those sites list some things. Jane and Jimmy can probably send you some more things upon request. But the important thing is let's stop doing bad stuff on the way to finding really good stuff. So, did all that with one puff of breath. So let me here for a minute and do your unclicking thing and see what kind of feedback.
While muting, I will make a exciting announcement to everybody that it's just hot off the press, just published, is our article demonstrating very large effect sizes in reducing of problematic sexual behavior from the first 3 OJJDP sites.
So as I'm unmuting people, there's quite a bit of background noise, so if you don't have a question or comment, please mute your own phone. Otherwise, this is an excellent opportunity to take advantage of Paul Stern. I'm shocked that no one even responded that I said you could use Paul Stern.
Yeah. Well, abuse me. All right.
Getting a lot of feedback. I'm not quite sure what it is, but if folks can mute themselves if they're not talking. Did folks hear what I said about the article that just got published?
So we do have a question coming in through, great. We do have a question coming through the chat box. A quick, Jane, if you'll just remind people of the article that was just published in case they didn't hear.
So published in the Journal of Sexual Aggression. It's just online now. The paper version is not out. It just came out this week. Is the summary article from the first 3 sites funded by OJJDP and the fantastic outcomes, large effect sizes, and reduction of problematic sexual behavior, as well as reducing general behavior problems, trauma symptoms, and parental stress, and increasing parental sense of support and skills. Post on the chat bar the link to the article, and when we send out the PowerPoint, we'll send out that link too.
Thanks, really exciting. We have a question from Allison Kelly. I'm very excited to get that in the chat box. Her question, can you briefly touch on the top policy solutions? We have the policy problems, but solutions are not as clear, at least me.
Well, I think generically, and it's the $4,000 question. The step, of course, is trying to influence policymakers with data and to give them the correct information. In the state, we're beginning, and I think this is happening in many states, we need to sort of roll back juvenile sex offender registration, recognizing that we have gone too far, unnecessary, in trying to find a balance. So it's the process of re-examining what we're doing and bringing those to better fit the data. So that process began 4 years. Elizabeth Letourneau at Johns Hopkins, who's done most of this research, has been tracking this on a state basis, and has said there are a variety of other states. She recently, at a plenary talk at the ASAC conference in July, where she just sort of listed the variety of organizations that have just come on board to sort of support that effort. So efforts are sort of underway try to roll back some of the inappropriate registration of juveniles. What policy is going to look like is there, and there are a variety of different proposals that have been put through. Again, maybe you do it with some kind of risk assessment tool. Those are still being created, so that's a bit of a problem. In the adult field, we have really good, effective risk tools. Juvenile field, they don't. But they're hoping that those things can get developed. But trying to figure out what the right rollback is. So again, this one size fits all is difficult. Whether it is you register after your second conviction, then a proposal. Does that really make any sense? Is debated. So the question is great. What policy remedies? And I think lots of those are coming out of Elizabeth Letourneau's shop. Actually, she is in charge. Her is public director for juvenile matters, and figure some of that stuff out. Part of it has to do with outreach programs for juveniles who have urges and have realized, boy, I'm attracted to the kid next door. What do I do about that? Or you go see therapists about some things, and you may have done something, or actually acted out and want to stop. Deport statutes, difficult obligations. I'm not saying that those shouldn't exist, but other ways of getting treatment for people who have those types of urges and want to stop early before they engage, and what kind of additional programs and policies can be created for that. That's underway, I know, at the moment. So your question is fantastic and needed. I'm not aware of anything that is, hold an answer right now, more than, hey, what we're doing isn't working. Let's take a look at the data and figure out how we can structure it back. Local level, I think it's taking a look in your own community, figuring out what your strengths are, figuring out what you're good at, educating your judges the best available knowledge, and then to build a system within your own community that makes some sense and takes advantage of your strengths and recognizes the unintended consequences, and then share information with others to say, hey, here's what we've done. It's working. Maybe we should take this on a statewide basis and on a larger basis. So you're at the beginning of that stage. That's a very long non-answer, but it's the perfect question. I just don't think there's not a bullet item list of things that.
And I think what you're sharing at the end fits very well with what's going on in these communities that have multidisciplinary teams that are looking at the cases and trying to determine what's the best track. What kids are first-time offenders early on and perhaps don't down the track of prosecution, or they go down deferment, or how to make those decisions as a team to be able to look at the protective factors, the services available to the community, not only for that child, but the child they acted out upon and the caregivers. I think there are a couple questions that are coming in. I'll pass it on to Jimmy.
Yeah, I think we had a question out of Charleston, South Carolina. You're unmuted.
This is Kelly LaPointe. I'm an assistant solicitor that prosecutes juvenile crimes down in Charleston. And Paul, I would echo the thing that you were saying earlier. We do not, it's very rarely that we would move forward with a conviction on a CFC charge, specifically because of the requirement that they be placed on the registry. There's a push in our legislature recently to make that registry requirement discretionary, and also a push to make it to where they can appeal the registry after a certain period of time. I would just be curious as to whether or not you felt those would be appropriate fixes.
South Carolina has really been sort of one of the reasons trying to do this, and obviously having MUOC in your backyard and Elizabeth Dame there has been really, really helpful. Having Ben Saunders in his team there has been really, really helpful. I would agree with what you're proposing. The appellate process, and Elizabeth and I debated this thing. It's an interesting scenario of who has the burden of proof to go, I'm not dangerous, oh no, yes you are. Where that plays out, I think, is still becomes controversial. I don't know what the right answer is, but I think that's where one of your sticking points is probably going to be is who burden is the burden to keep them on, or is the presumption to keep them on, and the burden is to say I'm not dangerous, take them off, or vice versa. So it plays out. Some jurisdictions, I think, in Florida, mind to a presumption that you come off, and the state has to prove that you still are dangerous. One of the problems, and again, it goes to the first question, is in the juvenile field we sort of, we lack solid actuarial instruments. Again, in the adult field, that's pretty much what people are doing. But with juveniles, because the actuarials are all static factors, there's things that can't change, and juvenile behavior, sort of by definition, is dynamic as brains develop and and maturity develops, it becomes harder to get those actuarial instruments. I think once those are developed, and I think they will be, they're out now that are iffy. I think that will end up being the key to how to do that, and it's going to be, it may well be a presumption of a mathematical thing. If you get a score of more than 4, suggests a high risk of danger. If you get a score of less than whatever, and start that as a starting point. I like what you're doing, Kelly. That process. Am I right that who has the burden of proof is sort of the argument in that legislation? Or witnesses?
Correct.
Yeah. So, and the point, as I'm urging you to do that, would be to at the beginning and make sure these discussions are being had based upon facts and data and research and the empirical data, which there is now an abundance of, and rid of this fear and this misperception of risk and this folklore. These legislators are moved by horror stories, and we really want them to be moved by numbers and data.
I don't know if it would be useful for Dr. Bonner to talk about what we have in Oklahoma, which is at the front end rather than it being based on what they're being charged or prosecuted on. It's based on a combination of experts really examining that child's current risky behavior to determine if registration is necessary. And Mark Chaffin and Barbara Bonner got that innovative legislation passed on really early on, and have limit then the youth that are on the registry to those that are at very high risk, and as you can imagine, a tiny percentage. Having actualization tables that predict a 2% is almost impossible to do, and so being able to really look at those individuals specifically and making those determinations. Barbara, is there things that you'd add to that?
Hi, Jimmy. I'm not sure what call-in user Barbara Bonner is.
Oh, okay.
So I will unmute people with the hopes that we will we'll get her. So give me just a moment. Start talking and
Sure.
we'll get
I'm
there.
Here.
Oh, great.
This was a law we passed, I think it was passed in 2001 or 2002, and it's for youth only over age 14. There have been maybe 7 on the registry, I think, since 2001. I don't think there are any on it right now. It has been, as Jane said, I think, an effective law in meeting the necessity of having anyone, if it is necessary to have anyone on a registry, and it's only available to law enforcement. It's not available to the public. So it has protected the youth's privacy, but those names are available to law enforcement. If there are any questions, I'd be happy to answer the questions. Okay.
I will unmute. We are getting toward the end of our time, and so by unmuting, I hope people will take advantage of this opportunity to talk to Paul, offer your questions and comments.
Was there another question? Looks like you said that Allison had a question.
No, her question's already been answered.
Okay.
Hey, Barbara, as long as Barbara Bonner, let me ask you one thing.
Yeah.
Do you agree with me that the step in changing policy is changing policymakers' beliefs about what to do?
Yeah, I think that's the first major step, huge step.
And that's still sort of where we are, is going, whoa, if you can turn the Valdez, you got to get it to slow down and commit to changing direction.
Yeah, I think, probably best avenue for that is really through OJJDP. I think it's a very well-respected agency within the federal government, and I think a strong move by OJJDP would be the most likely to be effective.
And my own personal preference is on a local office, county by county basis, that each office recognize this is what we do well, this is what we have in our community. Let's try to build a better mousetrap for ourselves that works with our skill set, and see if we can get our judges and our community to do things that are more formed, and see, is that working? How is that going? And maybe we can expand that. We need to do it locally with the resources available. And again, this one-size-fits-all, always problematic.
Fantastic, Paul. It's exactly what we see when we have provided training and technical assistance across the country. What works in LA can work in Charleston, South Carolina, and wouldn't work in Kansas City. And what works in Kansas City wouldn't necessarily, work in York. That they're really needing to look at what are the policies and procedures of law enforcement, of child protective services, and how can we change it so we can better identify the youth early and get them in services and be able to address the community safety. And
again, our own jurisdiction, for the 5 years we've been there, we have a published book of prosecution standards and guidelines. There's a public document. We have a public committee. We review it every X number of years that says, on these cases, this is where our priorities are. These are the things we want to accomplish. In this day and age where of funding and staffing needs being insufficient in everything that we either want to do or statutorily asked to do. We can't do all of that. So you decide. Where do you want your priorities? How do you want these things to do? And I would invite other committees, if they don't have such a thing, to explore that, especially in this area. Here's what the data. What do you want to do? What's the best solution? What can we come up with? What can we come that fits empirically and fits our skill set and fits our community desires?
Paul, we have about 60 seconds left. I wanted to let everybody know we're going to send out Paul's PowerPoint. We're going to send out the paper he mentioned about Dr. Chaffin, the link to the new paper on outcomes, and folks asked about information about the law that Barbara Bonner talked about earlier, and I'll provide a link to that information too. Hope this was helpful on our cross-site calls with the administration. We would love